to join us now with analysis on the closing arguments as we await a verdict is Georgetown Law lecturer Frederick Lawrence. Always good to have you here on the Noon Show, Fred. First, let's talk about closing arguments yesterday and which side you found to be more effective.
I think they both made the best they could of their case for the prosecution. It was highlighting the fact that this was not police work, that this was murder. The prosecutor said that over and over again, illustrating what they have to prove, which is not intent to kill, but intent for the conduct that led to death, and that the asphyxiation from the knee on the neck was a substantial cause. So I think the prosecution did a very good job of making their case. The defense has got a very tough case, as I've said with you before. I think they did the best they could trying to highlight that there is an attenuation between the knee on the neck and the death. I think that's the best they can do with that. I think it's a weak argument. They tried to say that Derek Chauvin was following police conduct and police practice. Now, keep in mind, he had some witnesses who said that, but the prosecution had very strong witnesses, including former supervisors of Derek Chauvin, who said just the contrary.
So there is this notion we often think of, a quick verdict is best for the prosecution, a longer deliberation is best for the defense. Today is the first full day that these jurors are deliberating. How much do people read into how long it takes this jury to reach a verdict? They do have 3 charges to consider.
They do have 3 charges, and it's a very serious case. I would read very little into how long it's going to take. In fact, I might suggest that in this case, it's exactly the opposite of the normal wisdom. And that is, if they went right out and they looked at each other and they said, you know, we have probable cause, we have doubt, we have a reasonable doubt, then they would have come back and they would have quit. That would happen fast. That's highly unlikely to happen. They've got 3 charges to work through. They got a lot of evidence to work through, and they know how serious a case this is. So obviously anything is possible. Very hard to predict what's going to happen in that room. I'd be surprised if they come back with a verdict today.
Now, Congresswoman Maxine Waters made some comments about the trial. The defense tried to use those comments as grounds for a mistrial, and the judge was clearly irritated by her comments, did not grant a mistrial, obviously. What is your take on this? Was this a reach by the defense or a legitimate ask?
It's a reach. I think Congresswoman Waters probably overstepped. I wouldn't be surprised if she knows that she overstepped. You shouldn't be saying that if a verdict comes out one way or the other way, that there'll be violence, or to be looking as if you're inciting violence. I don't think she really meant that. But let's talk about the case itself. Does anybody really think that that comment is going to influence the jury? I just don't see it. First of all, the jury's not supposed to be listening to that. From this point on, they're sequestered, so they won't be listening to that. And I think they're going to be looking at the facts of this. So I understand why the defense is saying that. You grab for every straw you can, but I don't think it was appropriate to seek a mistrial on that, and I certainly don't think it would be an appealable error.
Last question for you, and if you are representing one of the other officers involved who has an upcoming trial, what are the conversations that you're having with your client at this point?
Right now, you're watching with them. You're trying to keep them calm. If this case comes in and a guilty verdict, particularly if it's guilty on all counts, then you have a very serious conversation about whether it's time to think about a plea. If there's an acquittal, that's a different conversation. But if it's a conviction, I think you start talking about taking a plea and working out a plea with the prosecutors.
Frederick Lawrence, thank you for being here with us on such short notice. Of course, we'll touch base again once we do have a word of a verdict. Thank you for your time.
Stand by. Good talking with you.